welcome to another edition of the Evening Review. My name is Ockert. In studio today, I have Mr. Ockert Jansen. He is the Executive for Communications at Namibia's Business and Intellectual Property Authority, BIPA. Ockert, welcome.
Good evening, Ockert.
Thank you. We're going to talk tonight about the beneficial ownership requirements and especially about the deadline. But let's begin with the beginning. Ockert, what is beneficial ownership and why is it so important that information be gathered about it?
So beneficial ownership is a new legal requirement that came into the law in July 2023. It's for registered businesses to be able to declare who the true and ultimate beneficial owner is. Namibia is a member to various and party to various international agreements, treaties, and conventions, and there's this international intergovernmental organization which we are also member to. It's called the Financial Action Task Force, or the FATF. They are the global anti-money laundering watchdog, and they are the ones that now look at the various countries that they have membership to, and say, you know, this country does not have sufficient controls or laws or procedures in place to avert money laundering, terrorism financing, and proliferation financing. So having had assessments done in Namibia, we were found wanting in that respect, so that's why the laws were amended. But what is important, and I think for the viewers tonight, is for them to understand, so why beneficial ownership? What does it do? So if I own a registered business, what does it do? It's all about transparency. Business conduct, transparent business conduct. Let's assume there's a business that is doing money laundering. We need to know who the beneficial owners, who's actually benefiting from this entity. And as you know, Ogeto, the world over, people use legal persons, which is companies or close corporations or forms of companies, to launder money. Yes. So a beneficial owner, therefore, is someone that either has control or influence over a business, or they receive substantial economic or financial benefit. It doesn't necessarily have to be a member or a shareholder of this business. It could be someone very far distant that would just be able to receive the benefit from this business.
Okay. Well, it's been a couple of years since the law has changed, and
Yes.
You, as BIPA, you've been calling on business owners to disclose this information for a while, and there was a deadline which passed last week on the 16th of May. Since that deadline, how many businesses have you guys deregistered?
Okay, so we did issue a registrar's directive in terms of the BIPA Act. And in this directive, we directed businesses to comply. In fact, we implored them to comply by 16 May. And mind you, this beneficial ownership awareness raising and public education raising has been coming from 2023 onwards. So what the law requires is, it says that the registrar must list a company that is non-compliant on an inactive list to their BO requirements. This inactive list basically means that this business is temporarily suspended. That is why even the financial institutions have gone as far as announced a possible restriction on accounts if you are on this inactive list. Then the law further says that the registrar then must deregister a business that has been on the inactive list for at least a period of 6 months. So if we look from 2023, most businesses have surpassed this 6-month period, and we are now at a process where we have to get off the grey list of the FATF. Because if we don't get off the grey list, we'll go onto a blacklist. So we have to get our immediate outcomes upgraded to show that we are serious.
When you say we, you mean the country?
As a country. So coming back to your question, have we deregistered any businesses? We've now started flagging them as of this week. What does that mean? It basically just means that the ones that remained non-compliant as at the 16th of May would now, because deregistration is not just a press of a button and then you are basically ending the legal existence of this business. So you have to have due diligence. We must get now the files. We're doing it in a phased approach. We get the files, we check that what is still outstanding, what is not outstanding. We update our records online. Then we start flagging them for deregistration. It goes on to the next stage where the deregistration is done on the system. Then it goes to the next stage where it's done on the file. So the process has officially started. We've not yet deregistered because it is a process that is to be followed. But maybe we can quickly talk as well about how many people have actually responded. Because ever since 11 April, we had about 141,000 entities that were non-compliant. And you know, our total registry is about 232 or 233,000 entities. So as you can imagine, as of to date, when I looked at our figures, we have 93,000 compliant, which gives us a compliance rate of about 40%. And which leaves us with, again, still 130,000 plus entities that are non-compliant. But if we look from end of March until 16 May, we have seen a sharp increase in compliance, where we've seen approximately 10,000 entities complying with the BO requirement, which was a good sign. But it's still not enough because it leaves you with 130,000 plus.
Yeah.
And as the registrar, we understand that a lot of those companies may be inactive, but a lot of them may also be active and a lot of them may also hold property.
Isn't it possible for BIPA to get that information elsewhere, like the registrar of companies? And even if people do submit the information, what guarantee is it that they're telling the truth? Can't people just tell you what you want to hear?
Yeah. So we are the registrar of companies.
Okay.
And that is why the companies registry and the beneficial ownership registry are two different things. And I'll explain why.
Okay.
A lot of people have said, BIPA, why can't you just go to my file, get the information and just transfer it?
Yeah.
Unfortunately, it doesn't work like that. As I explained earlier, a beneficial owner may not necessarily be on your legal or your formal structure of a CC.
Okay.
Assuming that you and I own a closed corporation, we may be beneficial owners depending on the requirement for beneficial owners. If we own more than 25%, for instance, etc., or if we are senior managing member. But there may be someone in Afghanistan that is not anywhere on the business registry, that is not anywhere on our founding statement, that may receive financial benefit, or that may have control over the decisions being taken by this closed corporation. And this person, based on the definition in the Financial Intelligence Act, must then be declared as a beneficial owner.
Okay.
And that is why we cannot just copy information from one registry to the next.
Okay.
The second one is that this is a declaration. This is a legal declaration, and as such, businesses, whether it's a company or a closed corporation, or even a trust as for the Master of the High Court, people are making sworn declarations that the information is accurate and true as at the time of declaring or disclosing. Why is this important? Because you said, how do we know the information is correct? It is not up to BIPA to necessarily verify the accuracy of the information, although we do to some extent, including the banks. There are penalties, sanctions in the Act should anyone give misleading or false information.
Okay.
And in as much as you can even be sentenced to a custodial prison term. And you can even be fined up to 10 million Namibian dollars. So that is the punitive measures for giving misleading or false information. At what point in time will we know that someone has given that information? So let's assume that information comes to the registrar to say that no, but company ABC has declared this as beneficial ownership, but I know of someone that is actually controlling this entity. Then we will take action together with the competent authorities.
Okay.
Also, perhaps one of the competent authorities, whether it's the Namibian Police, the Financial Intelligence Center, or the ACC, if they start investigating an entity for alleged fraudulent activities, and they realize that what is on the beneficial ownership registry is not what the evidence that they may have, then it means that there may be additional charges for having provided misleading or false information. So other than the charges you may face for under maybe the POCA or the Criminal Procedure Act, you may then face additional sanctions, penalties, or even criminal liability under the Companies Act.
Wow, it's serious. And staying on the serious, let's deal with the issue. What happens to a business that is deregistered?
So, Ogeto, so as we know, it's like a child, and I want to give that analogy. When a child is born, this bundle of joy, you have it, you name it, you have to take care of that child until such a time that the life of the child ends. And then that child no longer has any rights. Obviously, there's a child that is a minor, won't be able to have certain capacities, but as they grow older or reach the age of 18 or 21, they get certain capacities. Similar to a business is a legal person, it's a juristic entity that receives a legal capacity upon incorporation. When this entity is deregistered, which means that this entity can sue or be sued, it can take action, it has standing in court, it can make debts and so forth. The minute that this entity is deregistered, it loses its legal existence, which means that it no longer exists. There are instances where the entity may be restored, and restoration for a closed corporation can be done through an application to the registrar, but it must be within a certain period of time. And you must show, if you want to restore an entity, you must show that at the time of deregistration, this entity was actually in business or in operation. So it doesn't help you want to come and restore an entity, but it was inactive for the last 5 years prior to deregistration. Whereas a company has to be restored through an order of court. So the court must then order the restoration, which means that an application must be submitted to the High Court, asking or giving evidence why this entity should be restored. It can either be done by the shareholders, it could also be done by creditors, depending what the scenario may be. But coming back, an entity loses its legal existence upon deregistration. However, if there are liabilities as at the date of registration, this entity is not absolved of these liabilities. So if I have loans or I owe someone money or there's any other case, it would continue as if the entity was never deregistered until the creditors are able to claim back the money. And of course, as we know that if the creditors go after the assets and there are no further assets, then the limited liability or joint and several liability clause may come in, and members or shareholders or directors may then, in very few instances, be held liable for the liabilities incurred by this business.
Ockert, we need to take a short break, but stay with us and come back. We'll be right back. Welcome back to the Evening Review. My name is Okito Craig, and with me in studio is Mr. Ockert Jansen. He's the Communication Executive for the Business and Intellectual Property Authority of Namibia, BIPA. And he's talking to us about beneficial ownership and the need to disclose that information. And we were talking about the deregistration that's happening or is imminent for companies that don't disclose. But you know, there are many of us who own property through a company, whether it be a CC or a PTY. What are the consequences if such a company is then deregistered?
Excellent question, Ogeto. And I think earlier we discussed the 130,000 plus entities that remain non-compliant to their BO disclosure obligations. Obviously, there may, if you just look at Windhoek, drive around, you see a lot of apartments, sectional titles, townhouses. You are in the CBD, you see a lot of buildings. You drive in the countryside, you see a lot of farms. A lot of, and these houses, buildings, and farms are what we call immovable property. Now, a closed corporation or a company may hold or may own property. And as such, as we know that there are a lot of people out there that actually bought a flat or an apartment or a townhouse in a close corporation for various reasons, or maybe a lot of farms that are, or buildings that are in PTYs. So what happens to the immovable property the minute that these businesses get deregistered? So this is a very serious matter, and this is one of our biggest concerns as the registrar, because the minute that this entity gets deregistered, let's say it held property, whether it's a farm or an apartment, and prior to the deregistration, there was no transfer of ownership from the CC or from the PTY to the member or the actual owner, the entity will get deregistered, and then the property would now vest in the state.
The government.
So the state would now own this property. There's a legal terminology for it. It's called bona vacantia, and it's when ownership has been vacated and this property or even movable property is now without ownership. So it now goes to the state. And how do you get back this property? There are two ways. You can either now write to the interim owner, which would now be the state, through the right channels. But in most cases, it would be that you need to make an application to court. Okay. And that is money, time, and effort. Yeah. Or alternatively, you could restore this entity if it is a CC. And then by virtue of restoration, you would then get your property ownership back. So it's a very serious matter, and people don't realize it. In fact, there are a lot of people, and we had this conversation a few months back, there are a lot of people that own property, but they don't know that the property is registered in a close corporation. Yes. A lot. Or people own farms, and they might have known, but as the years passed, you even forget that this farm is owned by a company. Yeah. And in those instances, it becomes very, very dangerous for these entities when they are deregistered. Yeah, yeah.
Sure, the implications are significant.
Yes.
Yeah, but I imagine it's not just in terms of home ownership. There must be so many implications.
Yes, very serious implications. And I've done various other interviews over the last couple of weeks, and people have said, but I don't own a business. Why should I be worried? Why should I even listen to this interview? Yeah. And I've continuously said that it affects the ordinary person on the street, whether you own a business or not. Let's take this example. Say you are employed by a locally registered business. Yeah. This business is non-compliant to its bureau obligations, and this business gets deregistered. What happens then is, once this business is deregistered, it ceased to exist. Yeah. Which means that if it held accounts at various financial institutions like bank accounts, the banks or financial institutions are now obligated to restrict transactions on this account, because technically and legally this entity does not exist anymore. Yeah. So the people that are employed by this business may ultimately feel the brunt. Yes. As they may not have salaries paid in time. Creditors and suppliers may not be paid at all or in time, because now you may have to follow a different legal process to get hold of the funds. You have to show, etc., etc. And the banks are very clear, because there have been directives issued by the Financial Intelligence Center as it relates to non-compliant businesses, because ultimately it's a risk to our financial system. Yeah. A business that is non-compliant, there may be illicit flows of money into the country or out of the country, and our country as a whole is also at risk. So that is one implication, for instance. How is the ordinary Namibian affected in other ways? Through procurement. Let's assume that there are Namibian companies that are registered here. They are non-compliant, but they may have been awarded procurement tenders. Let's take a very simple example of medication, whether it's life-saving medication, heart medication, blood pressure medication, or even oxygen. So this entity has the tender to supply Namibian government with this medication. They are non-compliant, they are deregistered. So what happens is they can no longer fulfill their obligations under the award that they've been given because they don't exist. Which means that this contract, there's a breach in contract and the contract has to be ended. So what happens to then the various state hospitals around the country that was relying on this medication or oxygen to be delivered? So that affects the ordinary Namibian sitting there, because you may be in hospital, you may be in need of oxygen or medication. So it's very serious. And as BIPA, that's why we took so long to get to the stage of deregistration, because we know the implications are so serious. And that's why we've also done a lot, at least in terms of public education, to drive. Let's say there's a company that has a tender along, let's say the airport road, for instance. It's almost done, and I'm just making an example. I'm not saying the one that has the tender to the airport road is non-compliant. But let's say they have a tender to any road in the country that is maybe critical for us to finish, that may help with logistics, that may help with decentralization of services. If they are non-compliant, they are deregistered. Upon deregistration, they don't exist, which means that that road that was supposed to be finished may also now lie idle until a new contract is awarded. And there are so many other implications. These are just a few for people to really understand that even though you don't own a business, you know someone that does. And it's your responsibility to tell them, listen, go to BIPA's website, go to BIPA. Maybe they own property and they don't know that the property is in a CC. So that is why we are calling on the ordinary Namibian to spread the message on our behalf.
But the deadline of 16 May has passed.
Correct.
So is there still time to save your organization, your company, or your property, as the case may be?
There's a small window, Ghetto. We've not extended the deadline at all. There's a small window for businesses to still creep under the mat. And why am I saying that is our earlier discussion on, has any business been deregistered yet? And I told you that it's a process for deregistration. So if there are businesses that would come in the next couple of days or maybe a week or two that still hand in, we are not going to say no, we won't take it, on condition that your business is not already at an advanced stage of deregistration. Because once that is done, then we cannot pull back, because we are as BIPA, we are an administrative body in terms of law, and once we've taken an administrative decision, it becomes very difficult, if not impossible, to reverse that decision, because in law we become functus officio, which means that we cannot overturn our own decision. Then it must be done through then a court or so forth. So that is why there is that small window for businesses to still come out.
Just one last question, because our time is almost up. In terms of beneficial ownership as a concept, say for instance I have a company with which I use the proceeds it generates to fund my child's education. Is the child then the beneficiary, or how far does it?
No. Yeah. So that's why the definition in the Financial Intelligence Act is very clear. A beneficial owner is one of three. They must have control within a company, which means they control the decisions, the hiring and firing, removing shareholders or directors and so forth. And your example of funding your child's school, I don't think the child would have that level of control.
Definitely not.
The person, the beneficial owner, must have influence to an extent that it affects perhaps how money moves in and out from the business. And then lastly, the last part of that definition says that the beneficial owner is a natural person that must receive substantial financial or economic benefit. And when we talk about substantial financial and economic benefit, we're not talking about giving your brother $1,000 a year or $10,000 there because he's struggling with something, or even paying for your child's school fees as part, because it's not substantial enough for that person to be a beneficial owner. But it would become substantial. And what is the difference between financial and economic benefit? Let's say it could also involve an asset of the entity. So let's say you bought a brand new Range Rover, but you don't drive it. Let's say there's someone in the north or in Swakop that drives it. Full time, this person is not a part of the ownership structure. This person is not a supplier or a creditor, but this person benefits from this assets. And this asset is substantial. If you're talking about a Range Rover, you're talking about a few $1 million in cash. Then that person should then be declared as a beneficial owner. Similarly, if $1 million or $3 million goes out yearly to a specific person in a specific country, that is a substantial financial benefit. And we're not really talking about, it's a risk-based approach, so we're not talking about these small funds that go out here or there.
Thank you very much for joining us. And ladies and gentlemen, please do as you were advised. Go to the site, the BIPA site, go and inform yourself and take action. Make sure that you are compliant. That's all for Evening Review tonight, but we'll be back again soon, so please join us again. Thank you very much.